Hi guys, welcome back to my channel. So today in this video I will continue the previous video about the Singapore Law Watch. So in this video I would read about admiralty law. A nature of admiralty law action in rem. 25.5.1 An admiralty actions in the rem is an action against the rest or thing, which is usually a ship but could also include a ship, include his apparel, tackle, and stores. The action in rem is characterized by service on an arrest of the rest. Although the defendant to an action in rem is the owner of the rest, the owner of the rest will only be liable personally if he has entered an appearance in the action. Unless released, the rem will in due course be judicially sold free of all encumbrances. The proceeds of the judicial sale of the rest are then used to satisfy the plaintiff claims and the claims of other parties, if any, according to an established order of priorities. However, frequently, this procedure does not culminate in the judicial sale of the rest, as the owner of the rest will furnish security for the claim, after which the rest is normally released when the owner elects to defend the action. The action thereafter continues as a hybrid action, in example as both an in rem and personam action. 25.5.3 The subject matter of Singapore High Court Admiralty jurisdiction is set out in limbs A to R of S. 3.1 of the High Court Admiralty Jurisdiction Act, hereinafter ACAGA, which is largely similar to S20. B. Invocation of Admiralty Jurisdiction. 1. The rest can only be arrested within territorial waters and port limits. 25.5.4 Singapore, the rest can only be arrested if it comes within the territorial waters as well as port limits of Singapore in adherence with the terms and conditions stipulated in the letter of authorization granted by the registrar for the arrest. 2. The court admiralty jurisdiction can be invoked in three situations: when vessel is either arrested or serving the writ in rem. 25.5.5 As far as the invocation of admiralty jurisdiction in concern as 4 of the HCAG permits in action in rem to be brought in three situations: an action in rem being brought against the ship or other property in respect of claim that come within S 3.1a until C and R of HCAGA. In action in rem being brought against ship, aircraft, or other property encumbered with a maritime lien or other charge, and an action in rem for claims that come within S 3.1d until Q of the HCAGA, which permit an action to be brought against the ship is connection in which the claim arises, provided that at the time the cause of actions arose the person who would be liable in an action in personam own charter or was possession or in control of that ship and is at the time of common commencement of the action. The beneficial owner or demise chartered by the ship, and actions may also be brought against any ship beneficially owned by the relevant person. Sistership arrest is therefore permissible under S.4.4 of the HCAGA. Admiralty jurisdiction is invoked when the vessel is either arrested or served with a writ in rem, whichever occurs first. A ship may be arrested as security for a claim which is to be prosecuted in the Singapore court or in aid of domestic or foreign arbitration. In the Europe, it was held a party cannot arrest a vessel in Singapore to obtain security in aid to foreign court proceeding, as opposed arbitration proceeding. See principle of one claim, one ship. Plaintiff cannot proceed against other ship named in the writ for some claim after invoking admiralty jurisdiction against one ship. 25.5.6 Given the sister ship arrest is law under Singapore law, when a writ is issued, the practice is to name of offending ship as well as sister ship can be proceeded against in one writ. However, after having invoked admiralty jurisdictions against one ship in respect of one claim, the plaintiff cannot proceed against any other of the ship named in the writ for the same claim, and should strike out the names of the other ship from the writ. The banco, if the plaintiff claim is severable, he can amend the writ to remove from it a part of his claim, which can then form the basis of a separate admiralty action in rem. However, where the exercise of right amounts to an abuse of the process of the court, it will be a law. The procedure for arresting vessel. An admiralty action is commenced by the issuance of a writ in rem. An arresting party has to apply for a warrant of arrest. An affidavit must be filed in support of this application, and an arresting party has the duty to make full and frank disclosure to the court of all material fact when making the application. Insofar as potential differences are concerned, the arresting party is not obliged to disclose all defenses which a defendant may reasonably raise at trial, but only those which are such weight as to deliver a knockout blow for the claim. The ship is arrested when the warrant of arrest is affixed for a short time of any mast of the ship or the outside of any suitable part of the ship superstructure. After a vessel is arrested, she comes under the custody of the Sheriff of Singapore if an application for a warrant of arrest is challenged. The plaintiff has not identified the person who would be liable on the claim in actions in personam. Show an arguable case for the claim is of a type of nature required by the relevant provision under HCAGA, and prove on a balance of probabilities that each of the requirement for arrest under S.4 of the HCAG is met. So the time is up, and the next article or the next information will be read in the next video. So don't forget to watch the previews and the next video, and bye bye.